Robert Krajcik here in Ottawa, Ontario, reporting for Rebel News. Want to share a quick update with you folks out there in the Dear Rebel News audience. Very short proceedings today. The judge ruling on one motion submitted by the defense. The defense requested an outright preemptive dismissal of a Carter application that's expected to be submitted by the Crown at the end of the trial. Now, I need to explain to you folks out there what is a Carter application and what does the Crown seek to accomplish via its forthcoming submission. Chris Barber and Tamara Lich are both being charged with a series of crimes related to their involvement with the 2022 Freedom Convoy. You all remember it. It was a massive, peaceful demonstration in downtown Ottawa with civil disobedience, broadly in opposition to what I have dubbed the COVID-19 enterprise, which was this apparatus of control and surveillance, a series of orders, decrees, mandates, edicts issued by different levels of government, ostensibly in pursuit of public health in response to COVID-19. A Carter application, if accepted, would allow the application of statements from one defendant to the other. In this specific case, it would allow for statements made by Chris Barber to be attributed to Tamara Lich as evidence. So a Carter application implies a conspiracy between co-defendants. So if the prosecution successfully argues at the end of this trial that both Tamara Lich and Chris Barber conspire towards an unlawful end, then again, evidence that can be used against one defendant can be used against the other. Again, specifically in this case, it means statements made by Barber can be attributed to Tamara Lich as evidence. Now, the defense knows that this application is coming, and they preemptively submitted a motion to dismiss the Carter application out of hand to prevent the judge from even considering it. The judge today decided that she wants to see the Carter application upon its submission. So again, like I said, that will be happening at the end of the trial. This was expected. This is not some sort of catastrophic bad news for the defense team, despite their own motion being denied. At the end of the trial, when the prosecution explains and submits its Carter application with all the details and arguments in its favor, the defense will have an opportunity to respond to those arguments, and at that time, the judge can decide whether or not to accept the claims or reject them. So at the end of the day, we can still see a rejection from Justice Perkins McVeigh to deny the Crown's attempt to link the two defendants as co-conspirators in this conspiracy via the Carter application's allegations.
So as the judge told us and reminded us again this morning, it's a bit of an unusual application that the Crown is relying on, where there's more than one person charged, and the Crown is trying to use what one person said against somebody else. So in this case, they're trying to use things that Chris Barber said against Tamara Lich and things that Tamara Lich said against Chris Barber. So there's a particular, somewhat convoluted series of steps that the Crown has to go through in order to try and use that evidence against one against the other. So that's essentially what we're dealing with here. So it's basically a three-step process that the judge has to look at.
And now, as far as today's proceedings, the brief moments that were there, the judge denied a motion from the defense to preemptively dismiss the Carter application prior to its hearing. Is that correct? And if that is right, what's the outcome of that in terms of future proceedings?
That's correct, and you put that very well in terms of our application to preemptively dismiss this application, because as the judge emphasized in her decision a number of times, this is not a decision on that application. This is not a decision on whether any of that evidence will be admitted, and even further down the line, this is not evidence that any of that evidence will be used or useful to her in terms of reaching her decision, even if it is ruled admissible.
The Crown must prove its claims of this conspiracy existing between the two defendants beyond a reasonable doubt. Isn't that the highest standard of proof or the highest burden required? And does that now apply to the Crown at the end of the trial, given this consideration of the forthcoming Carter application?
Exactly. So what it means is now that we will be hearing about this Carter application again at the end of the case, and at that point the Crown will need to persuade the judge, which she again reminded everybody this morning is at that point going to be a very high burden of proof beyond a reasonable doubt that there in fact was a conspiracy or common unlawful design, and they'll have to establish, at least on balance of probabilities, that both Ms. Leach and Mr. Barber were part of whatever specific common unlawful design the judge finds, if any. Basically, at this stage, we were forced to argue that it could not succeed, that there's no basis in law as to why the evidence that's presented could succeed on a Carter application. At the end of the case, we get to argue that it should not succeed, and we say it does not succeed because there's simply a lack of evidence of a common unlawful design as between Chris Barber and Tamara Lich in light of the evidence that's been heard and any potential evidence that could be heard going forward.
Folks, please remember that we require your donations, your contributions to maintain these in the field reports, to continue with this unique journalism. So please visit tamaratrial.com, help us out as you can, and stay up to date with our ongoing coverage.